I can't leave you hanging. Sorry about that. We're back. Nope, nope, nope. Nope, nope. I think after a certain number of hours, I I have to make sure I check my I check where I'm at with everything. So yeah, we should be okay. No, not a time limit. I think I just kind of yeah, ouch, popped off a little bit here. Yeah, no, not banned. No, oh no, I'm very careful about the community guidelines. You thought you're in jail. Oh my goodness. No. Nope. Oh gosh, no. Thank you all for coming back. Yes, we'll just take a minute here to get everybody back. I can't leave you hanging like that. We've got to have closing remarks. No, my setup here is such that it's a problem on my part. So my bad. That was a technical difficulty. So sorry about that. Looking behind the curtain. No. Everything is completely within the guidelines. I also have set just a cliffhanger. I set to make sure that I always set my lives for 18 and older just because I want my comments to be open, but I don't want to have any, negative issues with people who are underage. So I'm back. Sorry about that. No, I'm very, very, very careful to stay within the guidelines here. So we're all good. Had a little technical difficulty. Sorry about that. Thank you everybody for coming back. Thank you. Yes, no. Nope, we're good. Everything's okay. That was my mistake. I've got lots of things going on here to try to make sure that everything's working. So I think I missed one thing I needed to move over, and I didn't move over quick enough. So, but welcome back, everybody. Welcome back. No Emmy for me. Absolutely. You are absolutely correct. From Australia. Did I see Australia? Hello. Welcome. Yes. Oh, yes. Everything is fine. Sorry about that, everybody. I left you hanging there. Yes. Sorry about that. A technical difficulty. Yeah, sorry about that. Yes, I'm back. And, again, let me just reiterate, I'm just an attorney. I'm nothing special here. I'm just here explaining the law to people. I'm not, I don't have a fancy setup. I'm just kind of in the corner with my light. Just trying to kind of explain things. So thank you all for coming back. I appreciate that. Thank you. I wouldn't say necessarily a country lawyer, but I'm certainly not a high-tech multi big law firm kind of person. So yes, Ryan, women don't know the law. You're absolutely correct. No, not suspended. Everything's fine. Everything's absolutely fine. Sorry about that. That's my bad. Some technical issues. I've got my eyes on lots of different things here, and I missed one. I missed one cautionary moment I'd had with my own technical stuff. So, okay. So we're back. Welcome back, everybody. Welcome back. Now let's pick up where we left off. All right, where were we now? We were talking about the First Amendment, freedom of speech, right? We were talking about the Brandenburg versus Ohio test, which says freedom of speech and press do not permit a state to forbid advocacy of the use of force or of law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. That's the test. If we are inciting or producing imminent lawless action, which is likely to incite or produce that, we are not covered by the First Amendment. So that's the Brandenburg test. And that takes us back into Yes. Well, I mean, freedom of speech applies to the government. It doesn't apply to private people. So, and we do have restrictions. We do have some restrictions. We've got, the Brandenburg test, of course, we have obscenity, we have defamation, so we do have some of those. So we are looking to the specific language that he used on January 6th, this idea of we fight like hell, and if you don't fight like hell, you're not going to have a country anymore. And then telling the people in front of him to head to the Capitol, suggesting he was going with them, and told them to give members of Congress the kind of pride and boldness that they need to take back the country. This kind of language, we were kind of talking about, is this enough language then to be involved in the Brandenburg versus Ohio imminent lawless action question? So, and again, this will be up to the jury to decide. How have I been on live all day? It seems like it. It's only been a few hours, but I can't leave on a cliffhanger. We got to finish. We got to finish the indictment here. All right, so here we go. Defendant's exploitation of the violence and chaos at the Capitol. Now, we had bumped down here. Again, everyone, I apologize for clicking off there, but we're back. We're going to get right back into the indictment here, page 39. Before the defendant had finished speaking, a crowd began to gather at the Capitol. Thereafter, a mass of people, including individuals who had traveled to Washington and to the Capitol, defendant's direction, broke through the barriers. We had also gone through what happened then with that crowd. So after more than an hour of steady, violent advancement, the crowd at the Capitol broke into the building. Upon receiving the news, they told him there was a riot and that rioters had breached the building. And when advisors urged the defendant to issue a calming message aimed at the rioters, the defendant refused, instead repeatedly remarking that the people at the Capitol were angry because the election had been stolen. Now, I think that's good information to have to kind of back up where our intent is here, but I'm not sure which elements of that obstruction of the proceeding that this would fall into, other than just to give a bit of backstory. 2:24 p.m., after the advisors left the defendant alone in his dining room, Mike Pence didn't have the courage. Now, again, we've got a tweet which can be used. Didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a correct set of facts, not the fraudulent or inaccurate ones, which they were asked to previously certify. USA demands the truth. Again, this kind of language is on a private company, so we don't have First Amendment issues here. At this point, with this kind of statement, again, it shows mens rea, or the intent in this particular situation. 1 minute later, United States Secret Service was forced to evacuate the vice president to a secure location. This act itself is the direct obstruction of the proceeding. We had to have the vice president coming in as president of the Senate in order to put those elector votes in. And in order for that proceeding to go on, we had to have the vice president. Now we've got the vice president being forced to evacuate to a secure location. So we cannot continue in that proceeding. So there is where we've got that interference with that official proceeding. One of many spots, but this is very important. What do I mean, a private company? Well, Twitter, all of our social media places, they're private corporations, they're companies. And so they set the rules out for what speech you can do. I mean, we've got some equal protection rights and discrimination questions we can always turn to, but freedom of speech applies to the government trying to prevent your freedom of speech. So if you've got a private company giving you freedom of speech, that's different than the government. So like if you go to your boss and you say something really bad to your boss, you're like, you're a bleep, 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 and your boss fires you, you can't say, well, that's freedom of speech. Like, no, that's a private person. And you just use your speech against a private person, and freedom of speech isn't going to cover you. Now, if your freedom of speech, if your employer is the government and you're like, you know what, you're a bleep, bleep because you're awful and you're bad. Now we're talking about the government. Now the government's a party in that situation. So now maybe we can talk about that freedom of speech. But if we are just talking about a private company, we're not going to be invoking that freedom of speech. That's not really how it works. Again, because it's this idea of the government limiting or prohibiting your speech, not a private person limiting your speech. So the way that I like to put it is, if you go to a grocery store with your mom and your mom's like, you need to hush, you need to be quiet. And you're like, well, I don't have to have freedom of speech. Your mom's like, I'm not the government. I'm your mom. I'm the boss. So shut up. And she can do that because, freedom of speech does not protect you from your mother. I guess is how I try to illustrate that point. So we have to have the government involved. So these kinds of tweets, this kind of stuff that's set out is not going to be protected by that First Amendment because it's not the government trying to put on some kind of prohibition on your speech. All right. So the crowd chanted some awful things here, again, showing that intent and this imminent lawless action that was occurring. And then we've got the defendant repeatedly refusing to approve a message telling the rioters to leave the Capitol. And we've got two statements. Please support our Capitol Police and law enforcement. They're truly on the side of the country. Stay peaceful. And I'm asking for everyone at the U.S. Capitol to remain peaceful, no violence. Remember, we are the party of law and order. Respect the law and our great men and women in blue. Thank you. We have these two statements. 3:00, defendant had a phone call with the minority leader of the United States House of Representatives. Minority leader said that the crowd at the Capitol was more upset about the election, or the defendant told him that, than the minority leader was. So again, he's noticing what the crowd is doing. So what's the crowd's intent? How is the crowd behaving when we're dealing with that? So 417, we're back on Twitter from the Rose Garden, and we've got evidence again. We had an election that was stolen from us and finally asked individuals to leave the Capitol while telling them that they were very special and that we love you. Again, this goes into this idea of trying to obstruct that official government proceeding. 417, tweet at the defendant joined others in the outer Oval Office to watch the attack on the Capitol on television. Defendant said, quote, again, we're going to have direct evidence. If it's a direct quote, see, this is what happens when they try to steal an election. These people are angry. These people are really angry about this. This is what happens. That, again, can go to this idea that he knew that what he was saying could potentially incite this crowd to do imminent lawless actions. So that goes again to the Brandenburg test element when it comes to limitations on freedom of speech. 601, defendant tweeted, these are things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from the great patriots who have been badly and unfairly treated for so long. Go home with love and in peace. Remember this day forever. Again, going to intent and kind of where his head is at the time. On the evening of January 6th, defendants and co-conspirator 1 attempted to exploit the violence and chaos. Thank you again so much to my moderators. Let me just take a moment and say, I've been going on for hours and my moderators are just heroes. I thank you so much for your time and effort. I truly, truly do. Thank you. Thank you. Okay, so here we go. Knowingly false claims of election fraud to delay the certification. This is that obstruction of an official proceeding, which is what he's being charged with. Defendant, through White House aides, attempted to reach 2 United States senators. Again, this has to do with that disruption of the proceeding. Conspirator 1 placed calls to 5 United States senators. We've got more senators involved. Voicemail, we need you, our Republican friends, to try to just slow it down. This word, this phrase, to slow it down, is this piece of the code section that he's being charged with, right? Obstructing, influencing, or impeding any official proceeding or attempting to do so. So by talking with these senators, leaving this voicemail, he's asking them to slow down this official proceeding so we can get legislatures to get more information to you. And I know they're reconvening at 8 tonight, but the only strategy we can follow is to object to numerous states and raise issues so we can get ourselves into tomorrow. And again, listing out even a timeline of how they want to push the proceeding, ideally until the end of tomorrow. So that's some pretty significant information set out regarding the proceeding. In another message intended for another United States Senator, co-conspirator 1, repeated knowingly false allegations of election fraud, including vote counts certified by the states at Congress, were incorrect, and that the governors who had certified knew they were incorrect. Again, we're going into this idea of obstructing the proceeding. Oh, thank you. Thank you for that. Appreciate that. And illegal immigrants had voted in substantial numbers in Arizona, and that Georgia gave you a number, which is 65,000 people who were underage. Oh, and a heart. Oh my gosh. Co-conspirator 1 also claimed the vice president's actions had been surprising and asked the senator to, quote, object to every state and kind of spread this out a little bit like a filibuster. This is specific language with regards to that obstruction for that official proceeding, which is what he's charged with. Again, 701, calling U.S. senators, attack on the Capitol, obstructed and delayed the certification. So this is it. This attack is what delayed the certification for approximately 6 hours until the Senate and the House of Representatives came back into session separately at 8:06 p.m. and 9:02 p.m. respectively. At 11:44, there was an email to the Vice President's counsel advocating the Vice President violate the law again. Poor Vice President. I feel bad for him. And seek further delay of the certification. So again, we're even after they're coming back in session. He's trying to get the Vice President to come in. Co-conspirator 2 wrote, quote, so we've got evidence of this. Someone kept a record. I implore you to consider one more relatively minor violation of the ECA and adjourn for 10 days. Again, trying to stall this official proceeding to allow the legislatures to finish their investigation, as well as to allow a full forensic audit of the massive amount of illegal activity that's occurred here. 11:41 a.m., the President of the Senate, the Vice President, announced the certified results of the 2020 presidential election in favor of Biden. The defendant and his co-conspirators committed one or more of the acts to affect the object of their conspiracy alleged above in these paragraphs. This is a violation of United States Code Section 371. Okay, so that's a lot. That's a lot. Okay. Now, the rest of these counts don't set out evidence, so I'm not going to be really spending much time going through them, but we have this conspiracy to obstruct an official proceeding, which I've been talking about. That's the code section that we're talking about. So let's take a look at that. We've got United States Code 1512K. Whoever conspires to commit any offense under this section shall be subject to the same penalties as those prescribed for the offense, the commission of which was the object of the conspiracy. So we have a conspiracy here under count 2. Oh, thank you. Thank you for the heart. Oh my goodness. Now that takes us to count 3, obstruction of an attempt to obstruct an official proceeding. And I'm sure everyone's pretty tired of me showing you this section of the code, but let's just take one last look. Otherwise obstruct, influences, or impedes any official proceeding or attempts to do so. That is the section of the code that he's being charged under as well. And that's count 3. Count 4 is conspiracy against rights, which is this right to vote issue. Now, I haven't pulled that code section out before. Let me just pull it right now. You can take a look at it. 18 U.S. Code 241. So, oh, nope, that's obstruction of justice. Let me see here. Where we got? Wait, we've got conspiracy and oh, here we go. Okay, sorry about that. Oh wait, it's conspiracy against rights. All right, let's make sure I've got the right code section here. United States Code Section 241. So we've got 241, conspiracy against rights. If 2 or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if 2 or more persons go in disguise on the highway. So we've got highway robbery here. All right. So this is where our stage coaches are involved. They shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in the violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated this kind of abuse, or an attempt to commit aggravated this kind of abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life or both, or may be sentenced to this action. All right, so that's where we've got the conspiracy against rights count, which is count 4, 18 U.S. Code Section 241 here. Okay, that, everybody who has joined me tonight, that is the end of the indictment, going through the code sections and going through that First Amendment freedom of speech issue, that imminent lawless question when it comes to First Amendment freedom of speech. So, yes, you're welcome. Oh, my gosh. Oh, my goodness. Great job. Oh, thank you. Thank you. Yes, we did have some deaths. Oh, thank you for the flowers. We did have some very negative consequences for that. And we did have some very significant harm that was done because of that. Yes, that was a lot. That was a lot. Thank you from Australia. You're welcome. Oh my goodness. Thank you. Thank you for coming tonight. I appreciate that. Yes, we did. So we will see. We will see. I do know the prosecutor has been in touch with the family of the victims. So, I'm sure that's something that's on his mind as we go through this. Yes, they did. They did. Oh, from the UK. Oh, well, hello. Hello. Thank you for coming. Yes, yes. I find that, oh, thank you. I find that actually looking at the case law is so helpful in really understanding. So, oh my gosh, and a jellyfish, I'm trying to make it so that, you don't have to take my word for it. I'm not, this isn't what I'm saying. This is what the law says, and this is where you can find the law. So I try to be kind of clear about that, because I'm not trying to, just be like, well, this is what I think about it. This is more like, this is the law. This is what it says. So yes. Yes. Oh, Finland. Well, hello. Appreciate that. Please post this whole live. I will. I have a Tube of You channel that I do upload my live, so you can take a look on those just for people who have missed parts of it or are interested in listening to it again. I do post those. It takes me a little bit in order to get everything uploaded. I'm certainly not a tech person. I'm moderate, more of like a medium salsa level, I guess, when it comes to technology. But I do my best. I'm just a lowly attorney here, just trying to educate as best as I can, trying to get rid of that misinformation that's out there. So I do, yes, medium salsa. Oh, I've been on the live now for a few hours. I'm getting just a little bit loopy, but please bear with me as I try to answer some questions here. Yes, we are a constitutional republic. That's correct. And a constitutional republic is a type of democracy. I know. You're going to be mad about it. I know it. But, thank you. Thank you very much. My Tube of You channel is the same as my TikTok name. So it's set up. It's a very simple. It's literally, I just upload my lives to it. Sometimes if I've got a fun few videos, I might post them up as shorts, or wait, what are they called? Are they called shorts? I get everything all mixed up, but I just upload my lives so people can kind of go through, and you can skip around through the lives too, which I think is really nice. You can just fast forward to what you're interested in, so you don't have to listen to all of it. So yes, let me get my hands out of the way. Sorry about that. What's my legal perspective? There's a lot here. There's a lot of supporting evidence here. I know we're at probable cause for an indictment, so we're not at proof beyond a reasonable doubt. Again, anytime we go to trial, criminal trial, in front of a jury, it's a 50-50 shot. It does not matter how strong your evidence is. It's 50-50 every time. Based off of my years and years of being involved in the system. It's just, there's no way. You can't ever really predict how it's going to end up, but there are a lot. There's a lot of information included in here. So, I don't know how it's going to go. I'm going to say it's an incredibly well-written indictment. Both of the indictments that I go through, I've gone through the Florida one as well, but I kind of leave New York out of it. That's just too much for me. It's just, I was good with Florida, and then DC came down and I was like, oh my goodness, let's go through that because it's fascinating, academic fascinating. I try to kind of look at it from that academic point of view legally. So, but they're very, very well written. Everything is incredibly orderly. Every statement is backed up. Every count is backed up with a minimum of probable cause, which means there's a ton more evidence that I have no doubt that they have. That will all come out during discovery, of course, before going to a jury trial. So, but, for an indictment, because you only need probable cause, you don't have to include all of your evidence. Of course, the defendant is entitled to all of that evidence, and as it should be, as it absolutely should be. But for an indictment, we just, you just put out what you need for probable cause. And so that's what we've got at this point. And that's, a relatively low burden. It certainly is not anywhere near close to beyond a reasonable doubt. So, we will see. It seems like it. It seems like it. And again, I don't know him. I don't know anything about him, but, and I intentionally do that because I really just look to the four corners of the documents here out of court. I just look at it as a legal document. I don't really have much of backstory, for it because I try to just keep completely neutral on it and just go through the language. But, I can definitely see that both the Florida and the DC indictment have a lot of similarities with how they're structured and written. So there are definitely some similarities, but they're put together. They're put together pretty well. Just again, academically, if you're just looking at it from a legal perspective. So, thank you. Thank you. Thank you. Well, and again, we've got to put it in front of a jury trial. Our juries are fact finders. They are the ones that determine what's credible, what's not credible, and they have to make that assessment. And again, we've got probable cause, we've got charges, but we have to put everything in front of our fact finders and leave it up to them. And whatever they decide is what they decide. And I completely support our juries and our jury system. I've been absolutely had cases completely shattered by my juries before, but I respect the process. Like, if they found for the other guy, I didn't prove my case, and that's how it works. That's just how it works. And I've got support and respect for the jury system and our poor jurors that get called in and have to do all this work that really are just doing their civic duty. So I absolutely have nothing but respect for them. Would he ever plead? I don't know. At this point, I think any kind of admission of guilt, I really have no idea. There are so many things at play. It seems like you would want to plead out, get prison off the table, in this particular situation, although who knows if that would be recommended anyway. But if he was to plead, hypothetically, I would look at it like if there was some way for him to plead guilty without him having to plead guilty, like an Alford plea situation, I would say that's possible. But I highly doubt that with this level of evidence that the prosecutor would look to an Alford plea. So I don't know. And there's a lot going on with co-conspirators. Now, something about co-conspirators is that you can't just use co-conspirator testimony against each other. You have to have more than that. You have to have other witnesses, other evidence. And that's so clearly set out in this indictment. It's not just one co-conspirator against the other. This is a set of co-conspirators and then a whole bunch of other evidence that's been added in. So, and that's essential under the rules of evidence. You just can't do that with co-conspirators. It's kind of a special rule that goes into place when we have co-conspirators involved. What's the punishment if found guilty? I think we were reading through and it looked like, 20 years, I think. uh, 10 years, 20 years, 20, so 246, maybe 65 years maximum. It was kind of what we were looking at. This level of evidence. Oh, I just missed your comment. Circumstantial and indirect evidence. Well, the thing is with circumstantial evidence, you have to understand direct evidence is evidence of when a witness is testifying. That's what we call direct evidence. We also call that the best evidence. I think that's Rule 1001 under the Federal Rules of Evidence. I don't know where my rules went, but circumstantial evidence is everything else. So if you're talking about blood work, DNA, pictures, anything like that, that's circumstantial evidence. That's under the category of circumstantial. So direct is a witness or a victim. Circumstantial is the actual things that you're finding in and around. So the memos, the texts, and so on. So there's nothing wrong with circumstantial evidence. There's absolutely nothing wrong with that. In fact, most people prefer that. Most of our juries prefer circumstantial, have a hard time believing our witnesses are completely true. So let me just make sure here. Okay, it's 1002, my bad. Requirement of the original. The original writing, recording, or photograph is required in order to prove the content unless these rules or federal statute provides other rights. We call this the best evidence rule. So I've forgotten now why I was going on about that, but that's the Federal Rule of Evidence if anyone's interested in the best evidence. Oh, yes, I think I was saying we want to have the best evidence, but the best evidence can be circumstantial or it can be direct. It's, it really will. It just depend on the situation. Yes. And that's so true, Dawn, that our juries don't get all of the evidence that the rest of us have. Like we'll be watching from the outside and we won't have to worry about motions in limine or motions to suppress or evidence that's kept to the side for one reason or another. We'll get to see all of it, but the jurors don't. They're very, there's a lot of tunnel vision. They're just shown what has been approved. So, I think it's one of those, like when we look from the outside, we're like, oh, how could they possibly do that? But if you're actually sitting in the jury box, you've got a different set of rules. Oh, Mike Pence would absolutely have to testify. I have no doubt that he will be testifying. He plays a huge role in this as a witness, as a victim. I mean, he's got a huge role in it. What if this was Obama? Bring it on. Same thing. I don't care. Switch the name to Obama. I'll, be the first one to print it out and read it to everybody. Just sign me up. But at me if that ever happens, because I don't have anything right now. Am I single or married? I'm married. I am married. I was given permission this year on my wedding anniversary that I was able to share that. But yeah, no, we got married on the 4th of July. He humored me. We had a red, white, and blue wedding. We had sparklers and fireworks, and I was in white. My bridesmaids were in red, and he was in navy blue. So, we had a very patriotic wedding, and he's humored me ever since that day, and I'm very thankful for it. So, yes. Sorry. Nope. Sorry. Kind of off the table. Well, I think he's a pretty great guy. I met him when I was 17. So, we've been together a long time, a very long time. It's not all butterflies and rainbows, but it works for us. Somehow. Somehow. Yes. My YouTube is my same as my TikTok name. It's the very same. So, yes. Oh, yes. I was mature for 17. Let me just put that in as my defense. I'm one of the very rare people that did go through and get an emancipation when I was younger. I was emancipated from my parents. And so I was a mature 17 is what he likes to say. And he was 21. So we were within the legal guidelines, so to speak. So, you were born on the 4th of July. Oh, that's fantastic. Yes, I've always had a bit of a soft spot for the 4th of July. Always, since I was a little girl. So that's kind of what kind of carved out my destiny. Yes. My husband was 17. We were young. We were together for, I think think we were together maybe 5 years before we got married. So, oh yeah, yeah. No, I got emancipated. That, sometimes your parents just suck. Sorry, mom. But sometimes you just got to do what you got to do and take care of your life. So, I wasn't messing around. I had stuff to do. So I'm like, I do talk to my parents. I do talk to them. They're themselves. They are who they are. But sometimes you just gotta. Yeah, I was too busy to deal with their shenanigans. So I'm like, I'm out of here. I got stuff to do. But I do talk to them. I do. Um, yeah, sorry, mom, again. Oh, yours was a military guy. Oh, yes. Well, I mean, life just kind of does what it needs to do, and you just kind of go with it. So, yeah, I mean, I'm definitely not. I put myself through school. I took out a lot of student loans. Thank you, U.S. Supreme Court. I've worked my whole life, so I'm not at that kind of top of the pyramid, I guess, as you would put it. A little bit different, but that seems to work out okay. Yes, six is a mystery. I know. I know it'll be very interesting to see what happens. What happens with that? Um, yes, yes, we will see about that. Let me see here. Good night and thank you. Yes, thank you too. Thank you for coming. I appreciate that. I seriously appreciate that. Cool parents. Oh, nice, nice. Oh, I did well. Oh, thank you. That's so kind of you. Um, yes, yes, yes. I usually don't. I don't share much about myself, so I've clearly been on the live too long here. I'm gonna just take a few more minutes to kind of wrap up here, but what do I specialize in? I don't really specialize in anything at this point. I kind of have set myself up very luckily to be in a position where I can really kind of take whatever case I need to take, but I don't have to. And I think after you've worked in towards the litigation for a long time, you've done different kinds of cases, you can kind of plan things out. And I was able to do that. So do I think any of his family members will be witnesses? Maybe. Maybe there's not a privilege that would apply except for a husband-wife privilege, and that can be waived. So, but it doesn't seem like any of them are playing any roles unless someone is a co-conspirator that we don't know of. So I'm not sure. Um, we will see about that. But what state am I in? I am in the Central Time Zone. I have had a few problems, so I don't share my exact location, but I am in the Central Time Zone, right down the middle of the states. Yeah, she could volunteer to testify. Oh, that's possible. I'm not sure what the privilege rules are in DC, so I don't know. I don't know. Did she leave the country? I don't know. I should look into that. I wish her all the best. I do. Oh, thank you. Thank you so much. I appreciate that. I appreciate that. Um, yeah, they don't have a privilege. Kids don't. Children don't. You don't have a parent-child privilege. I mean, I don't know of any state jurisdiction that does. There could be some obscure jurisdiction I'm not thinking of, but out of all 50 states, I cannot think of a single case where they allow children to invoke that privilege there. Subpoenas coming. Yeah, yeah. Absolutely. Absolutely. Oh, hard issues. No, no, it's part of life. You just get up, you live your life the best you can and keep going at it. So, um, hypothetically, would this be a strong case? I would say I don't even have to hypothetically say it. I'm saying based off of this indictment, it looks very strong, a very strong case. But even with the strongest case you can imagine, you still only got a 50-50 shot with a jury. And I stand by that. I absolutely stand by that. So how will the jury be chosen? Very carefully, Dooley, very, very carefully. It's going to take a long time. It's going to take a while. It's going to be hard to do, but I trust the process. I absolutely trust that can happen. Take a case in Louisiana. No, I'm not taking any new clients right now. That may change in the future, but I really don't take any or do any work through TikTok. I leave this all completely just for educational purposes. I don't do any kind of business whatsoever, although happy to answer questions as best as I can. But sorry about that. Are you biased? Well, I think we're all biased to some degree. I think we all have some bias. Thank you again. Oh, you're welcome, Desert Skies. I try, though, to acknowledge what my biases are so that they don't taint when I'm teaching. And I try to kind of steer clear, like acknowledge this is a bias I have, so I need to be careful when I'm talking about certain topics. So I try to be careful about it. Yes. Oh, you're welcome. You're welcome. An unbiased jury. I think it's possible. I absolutely think it's possible. I mean, I really, again, we get trained and we have training on how to work with our juries and try to get the most unbiased juries. I mean, that's like there's a whole field of specializing in that to help us pick our jury so that they are unbiased. So I think it's absolutely possible. Absolutely possible. Oh, an excellent. Oh, thank you. Thank you. Thank you. Thank you. I appreciate that. Yes, I think this case, the magnitude of this case is really something else. I think there's so much information that we don't know. I really am I'm interested to know what will happen. Will I go viral? Oh my gosh, I hope not. I hope I don't. Yikes. I'm just carving out a little corner of the legal world. I'm not here for any of that shenanigans. So, do I think he's guilty? I truly don't know. I really don't know. I reserve judgment. I need more evidence, I guess is what I would say. I'd like to see more evidence. Based off of this indictment alone, I've got a lot of questions. And I think that that's fair to say. Absolutely have a lot of questions here. Oh, the stone in my ring. This is just a quartz. It's a cognac quartz. I got it a really long time ago. I cannot remember where or when, but it just, I just kind of, depending on the day, just grab it and see. But, oh, thank you. Thank you. Yes, and I'm sure a lot of people feel he's guilty. A lot of people feel he's not guilty. And, I think, again, our fact finders are really going to be our heroes in this case. Oh, thank you. I've kind of collected bits and pieces over the years. And, I'm a big fan of if you've got it, use it, or why have it. So I just kind of try to bring a little sparkle, a little sunshine into my life when I can. So thank you. Thank you very much. Is it comfortable to wear? It is. It is. Actually, it's a bit big. So I do have a string on the back to kind of, because it is a bit big, but yeah, it's very comfortable. It's very comfortable. I suppose I could use it as self-defense if I ever needed to, although I prefer bats. I've said too much, but yes. If you fight for your marriage, does that mean you're going to be physical? Yes. I mean, it's a good question. It's a valid question. What does fight for it mean? What does that mean? And is it in common vernacular, or is it in kind of inciting in a negative way or in a good way? When we're at a pep rally or we're at a protest or something, when we're trying to get people behind us, we can say that. Yeah, I think it would leave a scar. Absolutely. But yeah, I think that term fighting can absolutely be debated. Absolutely. Kind of questions do you have about the indictment? That's valid. That's a valid question. I really don't have much, which is one of the things that is fantastic about it, and is that I don't have much for questions. I've got, I think there could be additional charges in here. I think that would be interesting to see. I'm wondering if they held some charges back, which I'm sure they did. We all, as prosecutors, we would hold charges back because you don't need all of them to go forward in order to get justice. So we'll see. We'll see. That's really the only thing. Mistrial. Oh, I hope not. Oh my gosh, that would be awful. That would absolutely be awful. No, I don't think it's because he's running for office, Darlene. I truly don't. I think, we have we have a date, we have a crime, we have our code sections, we've got evidence. I mean, that's just kind of the basics. That's just the basics. Like if he wasn't running, that's fine. Or if he is, that's fine too. It's just like we've got some crimes, we've got some evidence. So, whether or not he's running again is really one of those things you just kind of take that off the table. Why did it take this long? Oh my gosh, this case is so complicated. I mean, you've got 7 states involved. You've got all these different working pieces, like all these different witnesses out of each state individually, all of the people in the Justice Department, all of these, oh my gosh, there's hundreds of people involved that need to be interviewed and their statements need to be taken and all this evidence has to be gathered. So, I mean, I guess I look at it like this seems like relatively quick, in my opinion. I mean, if I was putting this together, it'd be taking a long time. So I'm not surprised. I'm not surprised. I wouldn't put my attorney license on any conviction. Not on any convictions. Not worth it. It's not worth it. That license was so hard to get and took so much time and money. Nope. I'll just keep that to myself. Oh. Well, I don't think it can really hurt the prosecutor. I think we all go in as prosecutors knowing, hey, we're going to just do the best that we can. And if we win, that's fantastic. If we don't, I'm going to have to live with that. That's kind of part of the job. So, there's really no personal gain that comes with being a prosecutor. Yeah, you might, I suppose you can get some publicity, but you still have to go home at the end of the night and get into bed and think to yourself, like, okay, I just did that, and have to live with yourself. So we have to, all of those things have to be considered. So, what are the next steps? Yeah, so we have the arraignment today. So he pled not guilty, and he got his conditions of release. I think there's, if I heard correctly, again, I don't really follow all the sources, but he has to be careful about what he says and does as conditions of his release. The next step, yeah, we've got discovery and motions, and so they'll set out a timeline for everything, and they'll have to figure out when's discovery going to start, how's it going to start. So the government should already be giving evidence over to the defendant at this point, even today. There should have been evidence already given over just to try to expedite that process. So the discovery process will be gone through. Then we will have pretrial conferences. Preliminary hearing could be waived. The judge will set out the schedule for our pretrial motions, any affirmative defenses, motions in limine, motion to suppress, any of that stuff. There'll probably be multiple different things about media coverage and gag orders and so on. So all of that will be done too. So then she'll set out what our schedule will be. So all of that, then all that discovery, all of the depositions, all that stuff will have to be done within the guidelines that she sets down for that. So yeah, I'm sure there will be a lot of delays. I have no doubt. And I have no doubt. Oh, it needs to be present. Oh my gosh. No, thank you. No, thank you. Oh, goodness. No. You watch Fox News, so I'm sure you understand. Oh, I don't watch the Fox News. I don't watch any of the mainstream news. I have different sources for my information, which means I'm not as knowledgeable as I probably should be about stuff. But when are they going to press for the injured people caused by that's a great question, Rolene. That's a great question. And I don't know. I really don't know. I think that's a really big, as a huge and valid question. Absolutely. Because we do have people who were significantly harmed in this situation. So we will see. How long have I been going at it? Yes, it's been a few hours. I should probably start wrapping it up here. It has been, how many in a jury? Typically it's 12 plus a couple of alternates. So that's typically how we do that. Do you think they should televise the trial? I don't know. I really don't know. Again, we have to make sure we've got a fair trial. And if a fair trial can go on with it being televised, then fine. But without it being televised is usually a better chance of having that fair trial. And in this case, with the stakes so high, they want to make sure everything is done completely correctly. So we will see. Pre-sentence investigation pushes evidence that doesn't exist. Well, I don't know. That's something that it's a quasi criminal situation, so that can always be debated during those. No victim, no crime. There must be corpus delicti. Corpus delicti means actus reus plus mens rea, and that's what equals the corpus delicti, and that's an act plus an intent, and that's the body of the crime. So you don't have to have a victim in order to have a crime. That's not what that means, at least legally. So, yes, subpoenas are narrow and with purpose. Absolutely, they're court orders. So, all right. So, everybody, I thank you all so kindly for coming. But I think I've hit the 5-hour mark on this. Oh my gosh. Oh my goodness. I will need to take a break here for a couple of days. But thank you all for coming, for joining me, for my moderators. Oh my gosh. I'm so thankful. So many great questions, great points that everybody has raised. So I appreciate you taking some time out tonight. Yes, good night to you as well, Desert Skies. Thank you. Dances with Chickens. Yes, oh my goodness, I love that name. Yes, well, yes, oh my gosh, the mods, my mods, they're just amazing. Absolutely amazing. So thankful. Oh, yes. You have a good night too, Jay. And thanks again, everybody, for coming by tonight, asking questions. Hopefully everyone's learned a little bit about the First Amendment. I do other cases. This case has really been taking over lately, but I've got a docket set out for other case law to do. So I will be doing several cases actually on live rather than just going through the indictment. So I went to law school in the Central Time Zone, so I kind of keep my location a bit of a secret. But yes, I'm hoping Georgia. I mean, I know it's not about me, but it'd be nice if Georgia waited a little bit on that. Oh, thank you. Oh, you're welcome. Yes. Good night. Good night, everybody. Again, thank you so much for coming. I will be going. If anything new happens, I will, of course, be on as quick as I can, but yes. Oh, okay, excellent. But yes, if anything new comes up, but I also do I do go through case law, and I've got Lawrence v. Texas has been set on my docket. That's the next one that I will be putting up. So I will just make an announcement. You can see that on any of my videos, but if any new information, any new court filings come down, I will be on just to kind of explain those. So usually those are my last minute when I join, but usually I've got everything planned out. But yes, thank you, Amos. Thank you. Good night to you as well. And Roxy, paper, scissors, you have a great night. Yes, RJP, thank you. Thank you, everybody. So have a wonderful night, everyone, and I will catch up with you at a later time. So take care. Have a wonderful night.